Hello Law Matrix viewers. In this tutorial, we're summarizing the case of Pillay v. Shaik. This case deals with the validity of sale agreements when the prospective seller did not sign the documents, and the application of the important contract law doctrine of quasi-mutual assent. Background of the dispute. The first to six respondents, referred to as the developers, marketed interests in a sectional title property development called Lazy Lizard in KwaZulu-Natal in 2002. Each unit was to be owned by a close corporation, and the members' interests in these corporations were offered for sale. Mr. Selvin Pillay and Dr. Magala Solomon Motlanthe decided to purchase interests in the development. Mr. Pillay signed a standard form agreement on June 18, 2002, to buy a member's interest in the close corporation allocated to Unit 402 for 699,000 Rand. This unit was later allocated to Swaledale 9 Investments, CC. Dr. Motlanthe signed a standard form agreement on April 22, 2002, to buy a member's interest in the close corporation allocated to Unit 502 for 709,000 Rand. This unit was later allocated to MTR Trading, CC. Disputes arose regarding whether the offers made by Mr. Pillay and Dr. Motlanthe had been accepted by the developers. Legal proceedings and key findings. Durban High Court, Balton J. Balton J. ruled in favor of Mr. Pillay and Dr. Motlanthe, finding that the agreements did not need to be in writing under the Alienation of Land Act 68 of 1981, as the sale of shares in a company, even if it owns land, is not a sale of land. The court concluded that the developer's conduct led the purchasers to believe that valid agreements had been entered into, making the agreements binding based on the doctrine of quasi-mutual assent. Pietermaritzburg High Court, Full Bench, Nicholson, J. This court overturned Balton J.'s decision, concluding that the agreements were not binding because they were not signed by the sellers. The court believed that the parties intended the agreements to be binding only upon signature by both parties. It was accepted that the Close Corporations Act 69 of 1984 does not require the sale of a member's interest to be in writing, even if it relates to immovable property. Supreme Court of Appeal, Farlam J.A. The Supreme Court of Appeal disagreed with the full bench's conclusion that signed agreements were essential for binding contracts in this case. It clarified that unless a statute requires written and signed agreements, which was not the case here, a contract is binding if all other requirements for contractual validity are met, unless there was a pre-existing agreement requiring formalities before a binding contract could exist. The court affirmed that the doctrine of quasi-mutual assent could apply even when acceptance doesn't follow a prescribed mode, if the offeree's conduct reasonably induces the offerer to believe the offer was accepted according to that mode. Mr. Blake, acting for the developers, made misrepresentations through his agents, Mooney Ford attorneys, that led Mr. Pillay and Dr. Motlanthe to reasonably believe their offers had been accepted and binding contracts were in place. Mooney Ford's authorized actions, such as calling for deposits and guarantees, allocating close corporations, and requesting documents for transfer, amounted to a clear representation that the offers were accepted. Therefore, the Supreme Court of Appeal concluded that Balton J. was correct in holding the developers bound by the agreements based on the doctrine of quasi-mutual assent. Final order. The appeal against the order of the court a quo was upheld with costs. The order of the court a quo was set aside and replaced with an order declaring the agreements to be of full force and effect, with the seller's acceptance having taken place by conduct instead of signature. The sellers were directed to comply with their obligations under the sale agreements. That's the summary of this case. I hope it brings clarity. If this tutorial was helpful, please support the channel by liking this video and subscribing to Law Matrix for more summaries tailored for UNISA students. Let me know your next case request in the comments. See you in the next video.